Hello and welcome. Today, we're diving headfirst into the often turbulent relationship between human rights and policing in India. Now, India, as we know, has a vibrant democracy, a place where the fight for freedom is woven into the very fabric of its being. But like any nation grappling with its past and striving for a better tomorrow, the balance between security and liberty can be a delicate dance. Over the years, India's highest court has delivered a series of landmark judgments that have attempted to define this balance, to safeguard individual rights while ensuring law and order. We're going to unpack 5 of these landmark cases that have shaped the very relationship between the police and the policed. From custodial deaths to police encounters, from arbitrary arrests to the protection of women in custody, these cases offer a glimpse into the ongoing struggle to uphold human rights in a country as diverse and complex as India. So buckle up, dear viewers, as we embark on this journey through the annals of Indian legal history.
Our first stop takes us back to 1997, to a case that sent shockwaves through the Indian conscience, D.K. Basu versus State of West Bengal. This wasn't just a case, it was a deafening cry against the horrors of custodial torture, a practice, might I add, that is about as welcome as a cobra in a sleeping bag. The Supreme Court, in its infinite wisdom, decided to lay down the law, issuing a set of guidelines designed to protect those in police custody. First off, they said, if you're arresting someone, they have the right to shout it from the rooftops, or at least tell a friend or family member. Secondly, no more scribbling arrest memos on the back of cigarette packs. We need proper documentation, signed by a witness, because transparency, my friends, is the best disinfectant. And here's the kicker. Regular medical checkups every 48 hours. Why? Because apparently, some police officers mistook their batons for medical instruments. Oh, and one more thing. Disobey these guidelines, and you, my dear police officer, get to enjoy the delights of contempt of court proceedings. The message was clear. The right to life and liberty doesn't get checked at the police station door.
Now, let's fast forward to 2006 and the case of Prash Singh versus Union of India. This wasn't just about one instance of police misconduct, it was about fixing the system itself, giving it an overhaul that would make a mechanic proud. The Supreme Court, in its wisdom, decided it was time to treat the police force less like a rogue elephant and more like, well, a responsible arm of the law. So, what did they do? They brought out the big guns, the kind of structural reforms that make bureaucrats shiver in their sandals. First, state security commissions. These independent bodies were tasked with ensuring that state governments weren't using the police force as their personal plaything. Next, fixed tenures for police officers, because nothing says accountability like knowing you can't be transferred to the mosquito-infested backwater for refusing to bend the rules. And to ensure that investigations weren't just witch hunts in disguise, they separated investigation duties from law and order. But wait, there's more. They also created police complaint authorities because, let's face it, sometimes you need someone other than the police to complain about the police. It was a bold move, a clear message that the police weren't above the law. They were meant to uphold it. Chapter 3. Sheila versus State of Maharashtra, Protecting Women Behind Bars. From reforming the system as a whole, we turn our attention to a case that shone a light on the particularly vulnerable situation of women in custody. This is the 1983 case of Sheila versus State of Maharashtra, a case that reminds us that justice, like a good cup of chai, should be served with sensitivity. Sheila, a journalist with a heart of gold and a spine of steel, filed a petition that exposed the grim reality of women in police lockups. The conditions were often deplorable, the treatment worse. The Supreme Court, in response, basically said, hold on a minute. We can't be treating women like this. They issued a set of directives that, frankly, should have been common sense from the start. First and foremost, women and men should be held in separate lockups. Revolutionary, I know. And get this, they also said that women should only be interrogated in the presence of female police officers, because apparently the concept of a woman's dignity was lost on some people. But they didn't stop there. They also insisted on legal aid for women in custody, because everyone, regardless of gender, deserves a fighting chance in the legal arena. It was a landmark judgment, a victory not just for women's rights, but for basic human decency. Chapter 4. Pukal versus Union of India, when encounters turn deadly. Now let's address the elephant in the room, or rather, the rather uncomfortable topic of police encounters. You see, in India, encounter doesn't mean bumping into your neighbor at the grocery store. It often refers to something far more sinister: extrajudicial killings. The case of PUCL versus Union of India in 1997 brought this issue to the forefront. The People's Union for Civil Liberties, bless their souls, filed a petition challenging these extrajudicial killings, arguing that they were nothing short of state-sanctioned murder. The Supreme Court, in a move that surprised no one, agreed that, yes, maybe shooting first and asking questions later wasn't the best approach. They declared that every single encounter, death had to be investigated by an independent agency. No more sweeping things under the rug or blaming it on a mysterious case of the bullet did it. They also insisted on immediate FIRs, first information reports, following an encounter, because paperwork, while tedious, can be a powerful deterrent to foul play. And to add another layer of accountability, they said the National Human Rights Commission, or its state-level equivalent, had to be informed. The message was clear. The police may have the power of life and death, but that power comes with a hefty side of accountability.
Chapter 5. Anesh Kumar versus State of Bihar, Taming the Misuse of Power. Our final case takes us to the year 2014 and the case of Anesh Kumar versus State of Bihar. This case revolved around Section 498A of the Indian Penal Code, a law designed to protect women from harassment and cruelty within marriage. Now, while the law itself was well-intentioned, it was being misused like a free pass to a buffet of injustice. People were being arrested left, right, and center based on flimsy accusations, often as a way to settle personal scores. The Supreme Court, in its infinite wisdom, decided to put a stop to this free-for-all. They ruled that arrests under Section 498A and other similar laws where the punishment was less than 7 years shouldn't be automatic. They basically said, hold your horses, police officers. Before you go slapping handcuffs on someone, how about we do a little thing called an investigation? They insisted that the police officer must be convinced that the arrest is absolutely necessary. And get this, they actually have to record their reasons for wanting to arrest someone. This wasn't about giving a free pass to abusers. It was about ensuring that the law, meant to protect, wasn't being used as a weapon to persecute.
Go to the long road ahead. So there you have it, folks. 5 landmark judgments that have shaped the landscape of human rights and policing in India. We've seen how the courts have tried to rein in police excesses, to protect the vulnerable, and to uphold the constitutional right to life and liberty. But let's not kid ourselves. The journey is far from over. These judgments, while groundbreaking, are just pieces of paper. Their true power lies in their implementation, in the daily interactions between the police and the public. And that, my friends, is where the real work begins. It requires constant vigilance, a commitment to holding those in power accountable, and a belief that a just and equitable society is not a utopian dream, but a goal worth fighting for. Until next time, stay informed, stay engaged, and remember, the fight for human rights is a marathon, not a sprint, and it's a marathon we must win.